Greetings, we are back, as usual, giving you some hard-hitting information that you can use and lean on from multiple sources, all verified and credible. And saw a video earlier today, somebody's like, I think they're talking about you, and so I checked it out briefly, whether they were talking about me or were not talking about me. We'll handle the issue of the unlicensed practice of law at the end of this video, and any lying, looting, pandering piece of shit lawyer that would got the balls to bring a charge against me for practicing law, bring it the fuck on. I would fucking love handing your ass to you in court. All right, so that'll we'll touch that base at the end, but I honestly don't think they were talking about me, but I laugh because I have had lawyers tell me that before. We will bring charges against you for the unlicensed practice of law. And I started laughing. I said, as soon as you can produce your fucking license, big boy, then we can fucking talk about the unlicensed practice of law. Oh, I'm licensed. Oh, really? Really? By whom? By what state, motherfucker? And they're just like, well, I have a license. No, you have a fucking union dues card, part of a private monopoly, claiming that you motherfuckers know the law. I know the difference. So anytime your balls are big enough, big boy, you go ahead and bring your fucking claim, and I'll gladly hand your ass to you. So that would be a malicious prosecution situation, because they know they can't prove that shit. They only use that on people that are less inclined to have the information that has been bestowed upon me. Just know that you have a right to defend your family, your country, your friends, your community, express your grievances, and help your loved ones in court, because it's illegal to run a monopoly in this country, period, point blank and simple. And if these fucking cretins think that they've cornered the market and are going to bar anybody else from participating in it, they are sadly fucking mistaken. Personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from or dependent on the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. 16 Corpus Juris Secundum, Constitutional Law, Section 202, page 987. Sovereignty itself is, of course, not subject to the law, for it is the author and source of the law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all governments exist and act. And the law is the definition and limitation of power. For the very idea that one man may be compelled to hold his life or the means of living, or any material right essential to the enjoyment of life, at the mere will of another, seems to be intolerable in a country where freedom prevails, as being the essence of slavery itself. The Congress cannot revoke the sovereign power of the people to override their will as thus declared. In the United States, sovereignty resides in the people, who act through the organs established by the Constitution. The right of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agency of government. Supreme Court Justice Brady's spoke in the case of Olmstead versus the United States when he said, "Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of the conduct that are commanded to the citizens. In a government of laws, existence of the government will be imperiled if it fails to observe the laws scrupulously. Our government is the potent, omnipresent teacher, for good or ill. It teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. to declare that in the administration of criminal laws, the end justifies the means, to declare that the government may commit crimes in order to secure the convictions of private criminal would bring terrible retribution. Against that pernicious doctrine, this court should resolutely set its face, and so should every law enforcement student, practitioner, supervisor, and administrator. The sovereignty has been transferred from one man to the collective body of the people, and he who before was a subject of the king is now a citizen of the state. In the United States, the people are sovereign, and the government cannot serve its relationship to the people by taking away their citizenship. The people of the state are entitled to all rights which formerly belonged to the king by his prerogative. In Europe, the executive is synonymous with the sovereign power of the state, where it is too commonly acquired by force or fraud or both. In America, however, the case is widely different. Our government is founded upon compact. Sovereignty was and is in the people. It is a maxim, an established principle of the common law, that when an act of parliament is made for the public good, the advancement of religion and justice, and to prevent injury and wrong, the king shall be bound by such an act, though not named, but when a statute is general and any prerogative, right, title, or interest would be divested or taken from the king or the people, in such case he shall not be bound. It will be sufficient to observe briefly that the sovereignties in Europe, and particularly in England, exist on feudal principles. That system considered the principal as the sovereign and the people as his subjects. It regards his person as the object of allegiance. No such idea obtained here. At the Revolution, the sovereignty developed on the people, and they are truly the sovereigns of the country. But they are sovereigns without subjects, and have none to govern but themselves. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. To conceive a citizen of the United States who is not a citizen of some one of the states is totally foreign to the idea and inconsistent with the proper construction and common understanding of the expressions as used in the Constitution, which must be deduced from its various other provisions. The term citizen of the United States must be understood to intend those who were citizens of a state as such after the Union had commenced and the several states had assumed their sovereignties. Before this period, there was no citizens of the United States. A citizen of one state is to be considered as a citizen of every other state in the Union. When men entered into a state, they yielded a part of their absolute right or natural liberty for political or civil liberty, which is no other than natural liberty restrained by human laws, so far as is necessary and expedient for the general advantage of the public, the right of enjoying and defending life and liberty, of acquiring and protecting reputation and property, and, in general, of attaining objects suitable to their condition without injury to another, are the rights of a citizen, and all men by nature have them. All lands within the state are declared to be allodial. The feudal tenures are prohibited. On this point, counsel contend, first, that one of the principal elements of feudal tenures was that the feudatory could not independently allene or dispose of his fee, and secondly, that the term allodial describes free and absolute ownership. Independent ownership, in like manner as personal property is held, the entire right and dominion, that it applies to lands held of a superior to whom the owner owes homage or fealty or military services, and describes an estate subservient to the purpose of commerce and alienable at the will of the owner, the most ample and perfect interest which can be owned in land. There is no constitutional right to be protected by the state against being murdered by criminals or madmen. It is monstrous if the state fails to protect its residents against such predators, but it does not violate the due process clause of the 14th Amendment, or, we suppose, any other provisions of the Constitution. The Constitution is a charter of negative liberties. It tells the state to let people alone. It does not require the federal government or the state to provide services, even so elementary a service as maintaining law and order. Income tax. The legal right of a taxpayer to decrease the amount of what otherwise would be his taxes or altogether avoid them by means which the law permits cannot be doubted. The Supreme Court rules that general income tax are unconstitutional because they are unappropriated direct taxes. To this day, the ruling has not been overturned. The Supreme Court ruled that the 16th Amendment doesn't overrule the court's ruling in the Pollock case, which declared general income tax unconstitutional. The 16th Amendment applies only to gains and profits from commercial and investment activities. The 16th Amendment only applies to excise taxes. The 16th Amendment did not amend the U.S. Constitution. The 16th Amendment only clarified the federal government's existing authority to create excise taxes without apportionment. The 16th Amendment contains nothing repudiating or challenging the ruling in the Pollock case that the word direct had a broader significance since it embraces also taxes levied directly on personal property because of its ownership. And therefore, the amendment, at least impliedly, makes such wider significance a part of the Constitution, a condition which clearly demonstrates that the purpose was not to change the existing interpretation except to the extent necessary to accomplish the result intended. That is, the prevention of the resort to the source from which a taxed income was derived in order to cause a direct tax on the income to be a direct tax on the source itself, and thereby to take an income tax out of the class of excises, duties, and imposts and place it in the class of direct taxes. Indeed, in the light of the history which we have given and of the decisions in the Pollock case and the ground upon which the ruling in that case was based, there is no escape from the conclusion that the amendment was drawn for the purposes of doing away for the future with the principle upon which the Pollock case was decided. That is, of determining whether a tax or income tax was direct, not by a consideration of the burden placed on the taxed income upon which it directly operated, but by taking into view the burden which resulted on the property from which the income was derived. Since, in express terms, the amendment provided that income taxes from whatever source the income may be derived shall not be subject to the regulations of apportionment. Congress passes the public salary tax, taxing the wages of federal employees, 1939. 1940, Congress passes the Buck Act, authorizing the federal government to tax federal workers living in the states. 1942, Congress passes the Victoria Tax under constitutional authority to support the World War II efforts. President Roosevelt proposes a volunteer tax withholding program allowing workers across the nation to pay the tax in installments. The program is a success, and the number of taxpayers increases from 3% to over 62% of the U.S. population. You see why they like war so much? because they do little stupid shit like this and people get sucked into it. And after 3 to 5 years, nobody challenges it and they just leave it in fucking place. 1944, the Victoria tax and voluntary withholding laws are repealed as required by the U.S. Constitution. Remember, they can only put a tax in time of war, ladies and gentlemen, right? Okay. To support the arsenals, the barracks, the buildings, the ships, all that stuff. We were never supposed to have a standing fucking army. Okay. So anyway, in 1944, the Victoria tax and voluntary withholding laws are repealed as required by the U.S. Constitution. However, the federal government continues to collect the tax, claiming its authority under the 1913 income tax and the 16th Amendment, which we just showed you doesn't have any fucking bearing on you if you're not an agent and agency working on behalf of the District of Columbia and you don't proclaim to be a U.S. citizen. You don't have a duty to pay an income tax. All right. Erie Railroad versus Tompkins, 1938. The Supreme Court of the United States had decided on the basis of commercial negotiable instruments that Tompkins was not under any contract with the Erie Railroad and therefore he had no standing to sue the company. Under the common law, he was damaged and he would have to had the right to sue. Hence, all courts since 1938 are operating in an admiralty jurisdiction and not common law courts because lawful money, silver and gold, does not exist. Courts of Admiralty only has jurisdiction over maritime contracts on the high seas and navigable waters and navigable waterways. Supreme Court held that punishment for 2 statutory offenses arising out of the same criminal act or transaction does not violate the double jeopardy clause if each provision requires proof of an additional fact which the other does not. Justice Bradley, it may be that it is the obnoxious thing in its mildest form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. This can only be obviated by adhering to the rule that constitutional provisions for the security of persons and property should be liberally construed. A close and literal construction deprives them of half their efficiency and leads to gradual depreciation of the right, as if it consisted more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachment thereon. Their motto should be obsta principiis. It will be an evil day for American liberty if the theory of a government outside supreme law finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of the principles of the Constitution. Due process of law and the equal protection of the laws are secured if the laws operate on all alike and do not subject the individuals to an arbitrary exercise of the powers of government. Undoubtedly, the 14th Amendment, forbids any arbitrary deprivation of life, liberty, or property and secures equal protection to all under like circumstances in the enjoyment of their rights. It is enough that there is no discrimination in favor of one as against another of the same class, and due process of law within the meaning of the 5th and 14th Amendment is secured if the laws operate on all alike and do not subject the individual to an arbitrary exercise of the powers of government. The rule of equality requires the same means and methods to be applied impartially to all the constituents of each class, so that the law shall operate equally and uniformly upon all persons in similar circumstances. No man or woman in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. All rights and safeguards contained in the first 8 amendments to the federal Constitution are equally applicable. No man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who, by accepting office, participates in its functions is only the more strongly bound to submit to that supremacy, and to observe the limitations which it imposes on the exercise of the authority which it gives. No judicial process, whatever form it may assume, can have any lawful authority outside of its limits of the jurisdiction of the court or judge by whom it is issued, and an attempt to enforce it beyond these boundaries is nothing less than lawless violence. Okay, that's internal insurrection. All right. That's what domestic violence is. It's internal insurrection. It's lawlessness. Okay? Defendants urge that any act of judicial nature entitles the judge to absolute judicial immunity, but in a jurisdictional vacuum, that is, absence of all jurisdiction, the second prong necessary to absolute judicial immunity is missing. A judge is not immune from tortious acts committed in a purely administrative non-judicial capacity. Mulberry versus Madison, the particular phraseology of the Constitution of the United States, confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. That's why every police department's corporate charter states that they will uphold the United States Constitution and the state constitution for which they are in. Every fucking police department, every sheriff's department says the same thing, all right? So this is how you hold these people accountable, by having this acquired knowledge, demanding them to produce their charter, and then holding them to it, all right? I'm giving you the keys to the Ferrari. Take it out real nice. Be easy with her. She's a prom queen. Don't bring her back with, bent rims and a fucked up door handle, all right? Take it easy. Take your time. Break her in. Get used to using her before you decide to fucking floor it and run 6 gears, all right? In declaring that what shall be supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution, have that rank. All laws, rules, and practices which are repugnant to the Constitution are void. All right, that includes the unlicensed practice of law. Since the 14th Amendment to the Constitution states, no state jurisdiction shall make or enforce any law which shall abridge the rights, privileges, or immunities of citizens of the United States, nor deprive any citizen of life, liberty, or property without due process of law or equal protection under the law. This renders judicial immunity unconstitutional. You shouldn't need judicial immunity if you're doing your job right there, buckwheat. All right? You shouldn't need that kind of fucking protection. Where there is no jurisdiction, there can be no discretion, for discretion is incident to jurisdiction. In his dissenting opinion at page 140, Justice Douglas, if federal judges break the law, they can be prosecuted. Justice Black, in his dissenting opinion on page 141, said, judges, like other people, can be tried, convicted, and punished for crimes. The judicial power shall extend to all cases in law and equity arising under this Constitution. A judgment must be acting within his jurisdiction as to subject matter and person to be entitled to immunity from civil action for his acts. Jurisdiction once challenged cannot be assumed and must be decided, all right? The courts clarified the use of the same elements test set forth in Blockberger when it overruled the same conduct test announced in Grady versus Corbin, and held that the double jeopardy clause bars successive prosecutions only when the previously concluded and subsequently charged offense fails the same elements test articulated in Blockberger. Early precedent establishing that in a subsequent prosecution, while it is true that the conduct of the accused was one and the same, two offenses resulted, each of which had an element not embraced in the other. Judicial immunity. See judicial immunity pages for more citations. All right. Availability of equitable relief against judges. Note, we are not lawyers, yada, 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 the whole fucking disclaimer, all right? No big fucking deal there. We got to read it anyway. Copied verbiage. We are not lawyers. Judges have given themselves judicial immunity for their judicial functions. Judges have no judicial immunity for criminal acts, aiding, assisting, or conniving with others who perform a criminal act, or for their administrative ministerial duties, or for violating a citizen's constitutional rights. When a judge has a duty to act, he does not have discretion. He is then not performing a judicial act. He is performing a ministerial act. Nowhere was the judiciary given immunity, particularly nowhere in Article 3 under our Constitution. If judges were to have immunity, it would have only possibly be granted by amendment, and even less possibly by legislative act, as Article 1, Section 9 and 10, respectively, in fact, expressly prohibited such stating. Supreme Court cases supporting no license needed to practice law. If you ever get attacked for practicing law without a license, reference court cases. Picking versus Pennsylvania, all right, where it is said pro se pleadings are to be considered without regard to technicality. Pro se litigants' pleadings are not to be held to the same high standards of perfection as lawyers, and lawyers don't perfect shit anyway, except for their lying, looting, pandering piece of shit schemes, okay? Pro se litigants are to be given reasonable opportunity to remedy the defects in their pleadings. The respondent in this action is a non-lawyer and is moving forward in propria persona. Members of groups who are competent non-lawyers can assist other members of the group achieve the goals of the group in court without being charged with unauthorized practice of law. Litigants may be assisted by unlicensed laymen during judicial proceedings. Federal law and Supreme Court cases apply to state court cases. Next friend. A next friend is a person who represents someone who is unable to tend to his or her own interests. Right there, ladies and gentlemen. All right. Federal Rules Civil Procedure. United States Code, and this stands for annotated. All right. You got to go to the annotated section to see this, but it's there. Oklahoma Court Rules and Procedures, Title 12, Section 217C. If an infant or an incompetent person does not have a duly appointed representative, he may sue by his next friend or by a guardian ad litem. Inadequate training of subordinates may be basis for a 1983 claim. 11th Amendment does not protect state officials from claims for prospective relief when it is alleged that state officials acted in violation of federal law. Each citizen acts as a private attorney general who takes on the mantle of sovereign. It's okay to practice God's law without a license. Luke 11:52. God's law was here first. There is a higher loyalty than loyalty to this country. Loyalty to God. U.S. versus Seeger. The practice of law cannot be licensed by any state. And notice how they put this. Lowercase state and a capital letter state. Either way you go, you can't go fucking wrong. Nowhere can it be licensed, all right? This is Shawir versus Board of Examiners, United States Reports 353, U.S. pages 238, 239. In Sims versus Ahern's 271, S period W period 720, 1925. The practice of law is an occupation of common right. Go ahead and bring your charges against me, big boy, for practicing law. I will hand you your fucking ass in a New York second. A bar card is not a license. It's a dues card and or membership card. A bar association is that what it is, okay? A club, a association is not licensed. It has a certificate through the state. The two are not the same, all right? So if you're part of the bar club, you're part of an association. You didn't get your license from the state. You got your union dues card issued by the Supreme Court. All right. And the Supreme Court doesn't have the authority to issue its own fucking licenses. Only the state does. Otherwise, doctors would be issuing their own fucking licenses. Could you imagine that shit show? So, the practice of law is an occupation of common right. Nowhere can be found a competent attorney that is able to execute the proper remedy without embarrassing the court. Why? Because they're running a fucking scheme on you. They're running roughshod over your back. They're pissing on your back, convincing you it's fucking raining. They can't talk about the Constitution. They can't fucking protect your rights. None of them will swear to the fact that they're going to protect your rights and that they're going to clean up the disastrous fucking falsified record that's been created in these courts. For example, just starting with the names. Everybody's fucking name on those court documents is wrong. Everybody's fucking name is, all right? Secondly, they're not going to challenge the defects in the pleading whereas and wherefore the attorney, the prosecutor normally dreams up, and I say dreams up quite fucking liberally, you know, he dreams this shit up because he wasn't there with firsthand knowledge, and he creates some type of pleading absent a affidavit with firsthand knowledge or a statement of fact with firsthand knowledge from anybody making a claim. All right. So it's a fallacy. It's fraud upon the court. He's fucking you over. All right. So nowhere can be found a competent attorney that is able to execute the proper remedy without embarrassing the court. Why? Because he'd have to narc on his fucking fellow bar member brother, who's part of the same sick fucking organization of fleecing the American people, which I call taxation without representation. All right, other people say, well, no, it's not taxation without representation. I don't give a fuck what you call it, okay? It's fraud, okay? It's criminal. It's theft by taking, all right? It's taking advantage of the less learned people to live in a nicer house. It's theft. I don't give a fuck how you fucking spin it, all right? Corpus Juris Secundum, 2nd edition, volume 7, section 25. Asinger versus Hamlin, 470 U.S. 25, that no accused may be deprived of his liberty as the result of any criminal prosecution, whether felony or misdemeanor, in which he was denied assistance of counsel. It doesn't say in the Constitution you have a right to an attorney. It says you have a right to counsel. And there's a maximum of law that says he who confides in many for counsel often best makes the decision. It also says he who pays in haste pays twice, ladies and gentlemen. This is a substantive right here. The assistance of somebody learned in the law. Okay. At the present time, bar attorneys, public vessels, are not assistants of counsel, and defense is severely limited by being represented by an attorney, since the Texas Code of Professional Conduct permits a defendant to have only 4 choices of inputs in his defense. 1, what plea to enter. 2, whether to testify. 3, whether to appeal. And 4, whether to opt for a jury trial. Best said, a trial by jury. So with that said, I hope this helps you all out. I'm going to litter this thing with maxims of law later. I'm just going to pound them in there because I just reading through this again, it seems like I read through this at least twice, if not 3 times a month, because it's just so powerful, right? And if you catch the video I did below this video on Facebook, you'll see the rest of this. And I continue to grow this list. It's 36 pages at this point. And I continue to grow this list because the information that is in here is just so poignant and powerful, okay? And as you saw earlier, all courts are bound by the U.S. Supreme Courts. All of them. There is no excuse. So if a judge tells you to fuck off, he's not going to abide by that. You just let him know. That's fine. I go ahead and take exception to that as an appealable issue. I'm going to fry your ass for violating my rights. Okay? So the Clearfield Doctrine, when they're asking you for fucking some type of wherewithal in order to perform services, ladies and gentlemen, just know this. They are engaged in commerce, and they are 100% liable without any 11th Amendment qualified immunity. When the government acts as a private corporation, it diminishes its status to that of a mere individual and can sue and be motherfucking sued. All right? Justice shall be had freely. All right? It shall be swift and without payment and without delay. I love you guys. Thank you for all your support. Share this with your friends and your family. Help them ascend of the mind. More people are waking up in 2022 than ever before. And I hope this hard-hitting information will reach their hearts, reach their spirit, and help them comprehend what the founding fathers were attempting to do. All right. So quickly, history repeats itself. Why? Because good times breed weak men, and we've had some really good fucking times, haven't we? All right. And we've gotten some really fucking weak men out there. So it's time to get educated, stand up, sound off like you got a fucking pair. If you ain't got a pair, buy a set of brass fucking balls. All right. You can wear them in your pocket. They feel almost natural. Thank you, and I love you, and we'll talk to you soon.